Now, the principle in this question provides for two things. That is, firstly, no person shall be prosecuted and punished for the same offense more than once. Secondly, this constitutional right available under the Article 20 Clause 2 of the Constitution of India against double jeopardy can be successfully invoked only where the prior criminal proceeding has been culminated in a court of law as per the procedure prescribed therein, right? It can only be, let's say, invoked by virtue of a criminal proceeding which has culminated in a court of law as per the procedure established by law. This is another important point over here. Now read the facts. X is a citizen of India. He arrives at the IGI Indira Gandhi International Airport in Delhi from Indonesia, and he's caught with 1 kilogram undeclared gold with him, right? Now, as per the Customs Act, the custom authorities confiscated his gold. Also, a complaint was filed against him in the court of law for contraventions of the provisions of the Foreign Exchange Regulation Act. X challenged the proceedings under the provisions of the Foreign Exchange Regulation Act in the court of law as being violative of his rights under Article 20 Clause 2 of the Constitution of India, because he had already been punished by the confiscation of his gold by the custom authorities. So we have to basically establish whether he shall succeed in thwarting the action or not. In this question, the correct answer is B. That is, X shall not succeed in thwarting the proceedings under him against him in the court of law. Now, the reason why B is the correct answer is because if you just read the principle, it clearly says that no person shall be prosecuted for and punished for the same offense more than once, right? That is, a person cannot be prosecuted and punished for the same offense more than once. Now, for the first time when he was caught, that is, as per the Customs Act, the Customs Authority confiscated the gold, right? This was the first point, right? The second one was a complaint was filed against him in the court of law for violation of the FERA provisions, right? However, what can be said is mere confiscation of gold cannot be said, that is by the customs authorities, cannot be said to be an action of the court of law. That is, the act of the customs authorities does not mean prosecution, does not mean the court of law. Therefore, if second time the complaint was filed in the court of law, that would be a valid complaint, and therefore he shall not succeed in thwarting the proceedings, because in the court of law these were the first proceedings, and the the action that was taken by the customs authority can in no way be said to be the act of the court of law, making B the correct answer, right? Moreover, if we just read the last part of the principle, which says that successfully invoked only where the prior criminal proceeding has been culminated in a court of law, right? So in order to make a person in order to protect a person from double prosecution, or from being prosecuted and punished for the same offense more than once, it is important that at the first instance the person was prosecuted in the court of law, and again second time he was prosecuted, right? So in this case, in the first time he was the action was taken by the customs authorities, and second time it was by the court of law, right? Therefore, the correct answer is B.